Okay. Hello, everyone. This is Preston Clark. I am the president of EVERFI's compliance division. Very excited to be presenting with our friends at Jackson Lewis today, how to comply with GDPR requirements, what every U.S. company needs to know. As you might suspect, we have several hundred joining us today, which is great. We know that this is a timely and important topic. Before we get started and into introductions and onto the event, I just wanted to do a little bit of blocking and tackling to make sure everyone understands how the next hour will flow. We can jump to the next slide. So what you all need to know on this is basically, I'm sure you've done webinars with us before, but you're welcome to ask questions throughout. We're going to do our best to get to those. I am dialing in from Midtown Manhattan, so you'll have to excuse the sirens that may be in the background as I go through this presentation. We will be recording the event, so you will see a recording come to your inbox in the next few days. We'll also turn this presentation into a PowerPoint and PDF that we'll share as well. And then there'll be some additional resources from our partners at Jackson Lewis, and we're certainly here any way we can. We know that we're going to try to preemptively address as many of the questions that you all have as possible today. But for those questions we don't get to, rest assured that we're all here to help both at EVERFI and Jackson Lewis. So we will be sure to follow back up. And with that, let me tell you 30 seconds about EVERFI, and then I'm going to introduce our presenters, and then we will pass the controls and get into the substance. Many of you are EVERFI customers. It's about a 50-50 mix. So many of you know EVERFI. You are using us for training, which is great. And so we have a new GDPR course, which is why this topic is near and dear to us. But for those that don't know EVERFI, we're an online compliance training provider. We serve about 1,500 corporations, and to help organizations at a global level train their workforce on GDPR. We have recently rolled out a booster course to supplement our primary information security and data privacy trainings. That's 10 minutes in length, and that is in 20 languages, and that integrates with HRIS and LMS systems. So not here to do a product pitch, but just sort of from a contextual perspective, whether you're a customer or not, this event is an important one for us because a lot of our customers are asking for this, and we owe it to the market to have this available and available in a global format. Without further ado, our presenters, huge thanks to Jackson Lewis. This is a busy time for them as they're working with hundreds of organizations that are looking to meet their GDPR requirements, and so just grateful and thankful that they were able to set aside an hour to get us up to speed on the requirements for U.S. companies and how we should be thinking about these very expansive global requirements. First, Joseph Lazzarotti, principal at Jackson Lewis, founder and co-lead of the firm's privacy, communication, and data security practice. He edits the firm's privacy blog. It's a great resource, by the way. If you haven't been on the Jackson Lewis blog before, there's great articles about GDPR and other data privacy and data security issues. Great, just recommend checking it out. And he's a certified information privacy professional with International Association of Privacy Professionals. Second, Jason Gavision, principal also at Jackson Lewis, a certified information privacy professional, focusing on the matrix of laws governing privacy, security, and management of data. Also, find him on the blog. He co-authors many articles with Joseph. Last but not least, Mary Costigan, thank you so much for being on with us as well. She advises multinationals, national, and regional companies on emerging privacy and cybersecurity issues, including best practices and preventive safeguards. And she is also certified information privacy professional with IAPP. Because we're in multiple locations, this is where we do the jump. So we are going to pass the controls over to our friends now at Jackson Lewis, who will be driving the rest of the event. I will be wrapping up and coming back in at the end. We're going to do a poll and an opportunity for you all to ask some additional questions, both of Jackson Lewis and EVERFI. But from here on, the controls are yours. And Joseph, I'll pass this to you.
Good morning, everybody, or good afternoon. This is Jason. I'm going to be taking the lead baton here. Just a little bit about Jackson Lewis. I'm certainly not going to read through the whole slide, but we have 800 attorneys or over 800 attorneys in 57 locations. Joe, Mary, and I are all members of the Privacy and Data Security Group, and we wanted to thank Preston and EVERFI for having us today, and certainly wanted to thank all of you for attending. With that, we're going to jump right into what is GDPR and who's subject to it. And a question that we're getting asked a lot by a number of clients, and my guess is that this is the reason why so many of you are attending today. GDPR was adopted on April 14, 2016. It has an effective date of May 25th, 2018, coming next week. Again, that's the reason for the timeliness of this webinar. As it's not yet effective, it remains to be seen how it's ultimately going to be interpreted or enforced, but we thought it made sense to have a high-level overview or present this high-level overview for you all to get an understanding of what some of the requirements are and whether or not it may be applicable to you. The GDPR replaces the EU Data Protection Directive as a regulation now and not a directive. It's directly binding and applicable. It applies to all the member states of the European Economic Area. That's 28 European member states, as well as Iceland, Liechtenstein, and Norway. This is generally referred to as the Union. Again, given that we're dealing with the GDPR as opposed to US law, a lot of the names and the way that they phrase things are slightly different than here in the US, but we'll try and make it as simple and straightforward as possible for you all. It's expected that the GDPR is going to have global implications. As the GDPR builds on the directive, it's going to strengthen an individual's fundamental rights in this digital age. And the point here is that it allows the individual to control their data and who has access and how it's processed. It's going to have a broad jurisdictional reach, extending beyond just Europe. And it's going to carve out certain areas where the member states themselves, the individual countries in Europe, can enact more stringent data protection laws. As mentioned, the goal here is really to allow the individual about pertains to have a greater insight into the transparency and accountability of the data. So the jurisdictional and territorial scope. There's essentially three types of jurisdiction that might subject a company to the reach of the GDPR. One is processing personal data in the context of an establishment. While GDPR does not yet define an establishment, the Article 29 Working Party Guidance and Case Law that interpreted the directive previously suggests that an establishment is a fact-based determination, and it's going to imply some effective and real exercise of activity through some stable arrangements in the EU. Stable arrangements generally are going to suggest human and technical resources being permanently available. Think about a location, your operations, maybe you have agents in the EU. Again, that's going to be that type of stable connection that they're looking for. What are the ties to the European Union? That's the question that each company should be looking for or trying to determine at this point as they analyze whether or not the GDPR might reach to them. What might you do that might create an establishment? Again, do you have a location? Do you have agents, employees, et cetera, in the EU? The second way that this might be accomplished or jurisdiction might be accomplished is if you're processing personal data in the context of offering EU residents services or goods. Again, another new provision, it's undefined within the GDPR, but we expect that further guidance is going to be coming down with respect to that definition in the future. Some commentary to date suggests that it means that you're targeting the European Union market. You're making a systematic or regular activity where you envisage offering goods or services to the EU market. You're intentionally reaching out to that market in order to reach individuals in the Union. Simply by having a website that might be accessible, an email address is not determinative, and simply having a URL that might be able to be reached by people in the Union, again, is not going to be enough in and of itself to establish GDPR compliance. Some factors that support this targeting issue may include that you're offering your website in the local language, you accept the local currency, you mention that you're looking for customers in the Union, the accessibility of your services depending on an EU credit card, sending advertising in the local language, etc. Monitoring is the third way. So if you're monitoring union resident behavior or behavior that's occurring within the EU, guidance explains that where the purpose of the processing is to make decisions concerning a resident for analyzing or predicting their personal preferences, behaviors, or attitudes, you may be considered as monitoring and may therefore be subject to GDPR. For example, if you're doing some online behavioral tracking for advertising, tracking an individual's purchases, etc. A common example we see there is if you go to a website once and you maybe purchase something early in the day, if the advertising that appears on the side looks like something you looked at early in the day, chances are some of your activity is being tracked. Again, it doesn't matter there if you're targeting the union, as long as you're tracking some website activity, whether it's cookies or monitoring other user activity. With respect to this issue of resident versus citizen, GDPR applies to either, as long as the individual is located within the EU when the processing of the data occurs. So again, the key point to consider is where the individual actually is located when you're doing this type of monitoring or when you're reaching out to them. So what's personal data under the GDPR? It's just like the US, right? Simple answer is no, it is not. There's a much broader view taken in the EU. So we talk a little bit about, or we have a note here about the divergent historical context. There's 2 points there. One is beginning around the late 1960s, there was a number of countries in Europe that implemented legislation designed to control the use of personal information. Eventually, the Council of Europe stepped in and developed a framework of specific privileges and standards to prevent the unfair collection or processing of personal information. Their objective really was to develop a national legislation where we have some national rules and international standards which would govern to, again, touch on or avoid the instances where countries might have different standards. So what's personal data under the GDPR? Again, as mentioned, it is not like the US. It is much broader, and it pertains to any information relating to an identified or identifiable natural person. And those are typically defined as a data subject under the GDPR. An identifiable natural person is one who can be identified directly or indirectly by a reference, such as their name, identification number, location data, an online identifier, their physical, psychological, genetic, mental, economic, cultural, or social characteristics or factors are also things that are considered. So in other words, if there's any information that can identify an individual's person, public, or professional life, chances are they're going to be considered personal data under the GDPR. There's also these sensitive information. So here it's also under the GDPR, it's going to be referred to as special categories of data. What we want to think about here is the most sensitive data that an individual or that an organization might maintain about an individual. This is your race, your ethnic origin, political or religious opinions, your philosophical beliefs, your membership in a trade union, genetic information, biometric information, information about your health, sex life, sexual orientation. Again, anything that is overly sensitive to an individual would likely fall into this category. What's important to note here is that member states are permitted to have more stringent laws. So while GDPR may provide this national overview, if a member state has more stringent laws, you've also got to be compliant with any of those laws which may be applicable. The note here for all our HR professionals who are on or who are in attendance is that chances are you're processing or handling a significant amount of personal data, or these types of categories of data that we're talking about here. Personal information, this last bullet, that's how it's defined in the United States. It's really the goal there was to prevent financial harm, identity theft, or with respect to HIPAA and medical information. So the data elements are very limited. It's typically name, first name and last name, or first initial and last name in combination with your social security number, your driver's license number or other government ID, some biometric data, your financial account number with the PIN or passcode to gain access. Again, a more narrow prescription than what we're seeing under the GDPR. So what does it mean to be processing data? Well, what's important to note here is that under the GDPR, there's terms of controller. You're the individual who determines the purposes and means by which another entity, a processor, is actually going to process the data. So the processor is going to be doing it on behalf of the controller. And what is processing? While I'm generally not a fan of reading from the slides, this definition I think is important for us all. Processing is any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by an automated means. Here we want to be thinking about the collection, the recording, the organization, storage, alteration, use, dissemination, destruction of the data itself. Important to note is that this includes data that's both in electronic as well as in paper form. Again, from the US perspective, many of the state data breach notification laws only apply to electronic information or data in electronic form. Under the GDPR, we're looking at both types of data. Some examples of the different types of processing that you might all do in the HR context are collecting a resume, collecting a name and email for communication purposes, storing individual employee data or employee names and emails, forwarding names and resumes outside of the EU to the US, etc. You must have a lawful basis to be processing that data, and importantly, that can include the consent of the data subject. The processing must be necessary for the performance of a contract, for compliance with legal obligations, to protect some vital interests of the data subject, again, looking out for their own interests, or the legitimate interest of the controller, such as complying with law enforcement. Again, some examples of, or some additional examples of legitimate interests are to prevent fraud, performance of a contract, delivering products to the individual, and compliance with any sort of legal or tax obligations that may be in existence. So again, that gives us the high-level overview of the points of the GDPR, who it applies to, what are some of the common definitions that we're seeing, again, with the understanding that a lot of this is going to be subject to future regulation or certainly future guidance that's going to be coming in likely in the next few months. With that, I'm going to turn it over to Mary.
So the next question that we receive frequently is, do we need to appoint a DPO or a data protection officer? A DPO essentially is an individual located in the union who you appoint to oversee your data protection compliance, to monitor your compliance, or to serve as your contact point with the regulators. So who's required to appoint a DPO? Well, if you're a controller or a processor with an establishment in the union, you must appoint a DPO in two situations. One, your core activities consist of large-scale processing of special categories of data or criminal convictions and offenses. Or your core activities consist of large-scale, regular, and systematic monitoring of data subjects. So what are your core activities? Well, they're your primary activities. They're central to your operations. So if you're a manufacturer and you manufacture widgets, that's your core activity. Your HR functions may include processing on a large scale if you have a lot of employees, special categories of data, but that HR processing is ancillary to your business. In contrast, if you are a health insurance company, you are probably processing on a large scale, special categories of data, including medical or health information. So you would be required to appoint a DPO. The large-scale, regular, and systematic monitoring of data subjects is a little bit less clear. Regular and systematic monitoring has not been defined yet. Guidance suggests that systematic means there's a schedule or a scheme or a plan to what you're doing. So it would probably include all forms of tracking and profiling, such as behavioral advertising. So if you're a retail website and you use algorithms to monitor user searches and purchases and then make recommendations, you probably are required to appoint a DPO. If your website uses targeting or marketing and advertising cookies or otherwise tracks users, and you have a large volume of users visiting your site, you're probably required to appoint a DPO. Now, if you don't fall into those two categories, you are not required to appoint a DPO. If you look at this and you make an assessment, one of the requirements is write that assessment down. Write down your analysis as to why you don't fit into either of those categories and why you are not required to appoint a DPO. The GDPR is a lot about transparency and accountability. Often it requires you to analyze and memorialize your decision for compliance or non-compliance. and to retain that documentation. Unfortunately, very rarely does it tell you how long to retain that documentation. So if you decide you're not required to appoint a DPO, write it down, retain that document. If you decide you're not required, you could also voluntarily appoint one. And the benefits of that are operational advantages. You establish a contact point for the supervisory authorities in case there's an issue, and you're also demonstrating to them that you take data protection very seriously. Just a side point that Jason pointed out earlier, certain member states still require the appointment of the DPO, even if the GDPR does not. If you are not established in the EU, but you offer goods and services or monitor the behavior of individuals in the EU, you are required to appoint a representative in most cases. That's if you're a controller or a processor. The exceptions would be if you do not do large-scale processing, and you do not do large-scale processing of special categories of data or criminal offenses or convictions. The representative is a little bit different than the DPO. It's sort of more of a person that's appointed literally as your representative, so they can have liability that the DPO may not. So once you've determined that you're subject to the GDPR, what are your basic responsibilities and obligations? Well, it depends on whether you're a controller or a processor. The controller, as Jason mentioned earlier, determines the purposes for processing and the manner in which the data is processed. So it's why are you processing the data? What's your legal basis for processing the data? What data do you collect and process, and whose data? In contrast, the processor is the person or the entity responsible for processing on the written instructions of the controller. So they determine what IT systems or methods they're going to use, what type of security to use, and the means to transfer data. But they are strictly processing on the instructions of the controller. So what are the controller's responsibilities? Well, they're numerous, and I'll give you a list, but it is definitely not comprehensive. They must comply with the data protection principles, including lawful basis for processing, data minimization, suitable safeguards for cross-border transfers, data retention and deletion. If consent is required, they must obtain consent. They must provide robust privacy notices about the collection of data. They must conduct impact assessments for high-risk activities. They must implement privacy by design and default, which means if you're going to implement a new activity that involves personal data or start using new software, you need to know from the get-go whether or not there will be privacy implications, rather than instituting them and then finding out down the line that you have a problem. So that's a key component of controllers' responsibilities, privacy by design and default. You're also required to implement appropriate technical and organization measures for security, to use only processors that can guarantee compliance with the GDPR, and that would be through data processor agreements. You're required to report data breaches to the supervisory authority, and these two last factors are very important. You need to document and maintain records of your data processing activities, and document and maintain records of your compliance. So what are the processor's responsibilities? As we said before, to process the personal data given to you by the controller strictly on the controller's documented instructions. You're supposed to maintain the confidentiality of this data, ensure its security, obtain approval before appointing a sub-processor, assist the controller in complying with data access rights, return or destroy the data at the end of your activity, and notify the controller of a data breach. So the controller and the processor have several obligations and responsibilities in common. Just to highlight those, they both need to document their processing activities. They both need to document their security measures. They both may be required to appoint a DPO or a representative, and they both need to ensure adequate protection for cross-border transfers of data. There are two differences that I just want to circle back to. Processors do not need to obtain the consent of the data subject to process the data. Since they are processing data on the instructions of the controller, it's the controller's obligation to get that consent. The second difference is breach notification. The controller is required to notify the supervisory authority and perhaps, depending on the circumstances, the affected individuals. The processor is only required to notify the controller. So that leads us right into data breach requirements, data breach notification requirements. It's a new concept under the GDPR. It is modeled on the US state laws. So for those of you who have had the unfortunate experience of dealing with a data breach, you'll recognize some of these requirements. The controller is required to notify the supervisory authority within 72 hours of becoming aware. So the trigger is becoming aware. That means a reasonable degree of certainty, not a suspicion. So because you need a reasonable degree of certainty, that gives you a short period of investigation. The GDPR defines a breach of security, and I'm going to read you the definition, which is a little clunky, as a breach leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data that's transmitted, stored, or otherwise processed. So it's really more than just a security breach. It's a security breach that leads to a personal data breach. And based on that definition, there are essentially three types of breaches. There's a confidentiality breach, an integrity breach, and an availability breach. Confidentiality means that there's been an unauthorized disclosure of the data or access to the data. An example would be if I created a spreadsheet with employee names and social security numbers, and I emailed it to the wrong address or faxed it to the wrong number. That's a breach of the confidentiality of that data. If I click on a phishing email that entices me to send this spreadsheet to a fake email address, that's a breach of confidentiality. If a hacker accesses and downloads personal data, that's another confidentiality breach. An integrity breach is the unauthorized or accidental alteration of data. In other words, the data is altered, corrupted, or no longer complete. So that could happen if you have a system crash. When the system is restored, the data is no longer complete. And the third type of breach is the availability breach. It's unauthorized or accidental alteration of data. It's accidental or unauthorized loss of access to or loss of control of the data. So, for example, if a hacker installs ransomware on your system, it encrypts the data and it renders it unavailable. If you do not have a backup for that data, that's an availability breach. If you have a sales person, they lose their laptop and the laptop contains the customer database and there's no backup, that's a loss of availability. So those are when you would be required to notify the supervisory authority within 72 hours. The controller is only required to notify the affected individuals if they believe there's a high risk to the rights and freedoms of those individuals. So what is a high risk? Well, a high risk is when the incident results in physical, material, or non-material damage to the individual. So you have to do an assessment. And again, this is an assessment that you need to document and retain that documentation. You need to look at what type of breach it is, the nature of the breach in the data, the sensitivity of the data, the volume of the data, and the severity of consequences to the individuals. What would material and non-material damage be? Examples would be discrimination, identity theft or fraud, financial loss, or damage to reputation. So if you have special categories of data that were involved in this breach, it's most likely going to be high risk. If you make a determination that is high risk, you need to notify the individuals as soon as reasonably feasible. There's no definition there's no further definition on what reasonable feasible means. Again, if you decide that there is no high risk, you need to document that. Now that's what the controller has to do. The processor is only required to notify the controller, and the time frame for that is without undue delay after becoming aware. The notice content that you are required to give to the supervisory authority is comparable to that in the US. It would include the type of data, the nature of the breach, the number of affected individuals, the number of records, the DPO contact information, a description of likely consequences of the breach, and description of measures that you've taken to mitigate. So two key takeaways from data breach notification. One, have an incident response plan, because the turnaround time with the supervisory authority is very short. 72 hours is very short, much shorter than you experience in the US. The second important thing to note is if you have a data breach, it could trigger an investigation into your security measures. So you want to be prepared.
Thanks, Mary. This is Joe Lazzarati. Before we get into the next slide, I think it's a good segue to talk a little bit about, in a situation where there's a data breach and a breach that affects data in the U.S., personal data, personal information in the U.S., personal data of EU residents, we get questions from clients is, how do we handle that? What are the considerations? Who do we notify first? What drives our process? Of course, it's going to depend on the circumstances, the states that are affected, the kind of information that's affected. But I raise this only to point out that organizations that have operations, obligations that cross borders, they really have to start thinking about this, because they may find themselves in a situation where one law, perhaps the GDPR, really drives what their obligations are or what they have to do or report in the US, because the time frames are different. Maybe you have 72 hours in GDPR, but you have 30 days in Florida or 45 days in another state, or 60 days under HIPAA. The point is that you have to figure out which law do we follow. If we notify employees in Europe, but we don't notify employees in the US, is that okay? It may be okay legally, but is it okay practically if colleagues are working with each other on projects and one gets a notice and the other doesn't? So there's some real issues with when you go through and try to adopt the GDPR, if you have to adopt it. How do you adopt it as a practical matter? How does it affect your other operations? For a number of years, we've worked with some clients that wanted to adopt global privacy standards, and there's some sense to that. Certainly administrative convenience, the ability to train in a more consistent way across borders helps. But obviously there can be some concerns with that, because if you apply a lot of the rights, for example, that EU subjects have globally, there are a lot of things that people in the US may not have the right to, that they suddenly would have as a matter of policy, but not of law. So these are some considerations that I think companies are struggling with in terms of how to bifurcate or trifurcate the different data security obligations and compliance requirements. So with that is another example of this issue about looking at things that apply to our organizations that may apply differently or certainly be different than what we may be used to. Consent is one of those areas. I think in the US, we deal a lot with employers and companies with their customers or their patients. And, in many ways, consent can be obtained in a way that's, direct or affirmative, but it can also be obtained in ways that are implied. A lot of companies will post website privacy statements and feel pretty comfortable, in many cases, relying on the implied consent that when someone uses their website, they would have, although I'll make this a little secret, I don't always use to read the privacy statement on the websites I go to, so don't let that out. But I think that's probably true for a lot of people, that they don't read the website, but yet they may be treated as having complied, having consented to those terms when they use the website. That's not the same in GDPR, right? So in GDPR, consent is something that's really a function of wanting the individual to have control over their data, as well as having a genuine choice as to whether they can actually grant that consent or not. It happens to be one of the 6 lawful bases under the GDPR that permits a controller to process an individual's personal data. In order for consent to be valid, it has to meet certain principles. One, it has to be freely given. It has to be specific. It needs to be informed consent. We'll talk a little bit about that. It needs to be unambiguous. So, for example, we want to make sure that there's no doubt that the individual gave consent. So under the directives, there was some implied concepts that allowed consent to be recognized, but under GDPR, for example, if you're going to use a tick box, that tick box has to be something that the person actually clicks on to indicate their consent. It can't just be that the box is already clicked and they just don't choose to unclick it. So things like that are helpful to ensure that the consent is unambiguous. When consent requests are made, they have to be set aside from other materials. So there has to be, it can't be something that's buried in an agreement. May even be best to have consent as part of a separate document. Consents have to be specific. You have to obtain consent for each type of data that's collected and for each purpose that it's collected. So you have to avoid the bundling of consent so that you're not having consent for a whole bunch of different purposes. So if so you want to think about that when you're writing your contracts or your website statements, so you're not just having a whole bunch of purposes or collection of data subject to one instance where the person is giving consent. Consent also has to be informed to give you a sense of the kind of information that you need to obtain or provide to the individual to get that consent. You want to identify the controller who could rely on the consent. You want to make sure that it's clear what the purpose for processing is, for which the consent is subject. You want to make clear the type of information that the person is consenting to the processing of. You want to make sure that you make clear the right of the individual to revoke that consent. And you want to make sure that the person knows that the consent involves, if it's applicable, the transfer of data outside of the union. So these are some issues, these are some things that you want to make clear are provided so that you can say that the consent is informed. In April, there was some additional guidance on consent that was provided by the Article 29 Working Party. I think on April 10th it was issued. They made a number of points in that guidance to try to help clarify consent after 31 pages. And so, if, again, just to kind of give you a sense that when you go through this kind of guidance, just on the issue of consent, it kind of indicates the significant difference between the way consent is handled in the EU and the way that consent is handled in the US, just as one example of comparison. In that guidance, they made clear that in an employment context, it's really going to be rare in which a consent is going to be considered to be freely given by an employee because of the imbalance in the relationship between the employer and the employee. So consent is really going to be recognized in that context only in exceptional circumstances. So the ability to use consent as a lawful basis in employment is going to be pretty rare. Even if you have consent from an individual for the processing of their data, it doesn't absolve you from other principles under the GDPR. So, for example, if you get consent, you still need to be sure that you observe fairness and proportionality, and that the collection of the data doesn't allow you to use it for purposes that weren't provided originally in the consent. So there's things that you still need to think about when you obtain consent from someone. It's not an open license to use and process the data however it is that you choose down the road. I think, as Mary mentioned, only controllers must obtain consent. Explicit consent is required for collecting special categories of data, which Jason summarized above. So as you can see, there's really a whole number of special rules that apply for consent. And again, it really gets down to this principle of whether the consent was truly given. Does the person have control over their information? If they revoke their consent, for example, they can't have some kind of detriment applied to them. So you have to think about all those things when you're trying to use consent as a lawful basis to process information. The next question is, what do we do about data security? Are there any special requirements? I think Mary or Jason may have touched upon this generally, but in the US, again, just as a basis for comparison, it's a lot of different standards that companies are struggling with here. And likewise, in the GDPR, they both in the U.S. and the GDPR, there's not a required technology standard that must be followed. There's no specific framework. There's no level of encryption that you must adopt. And I think there's a good reason for that. One, because technologies are going to change and the law can't keep up with those changes. So you need to have a flexible standard in order to maintain security of information. So again, the GDPR doesn't technically require a written information security program or a specific framework or technologies. What it requires is that you implement organizational and technical measures that really are appropriate to the size and the nature of the organization and the kind of personal data that is processed. It doesn't require absolute security. It requires appropriate security. If you're familiar with, for example, the HIPAA security regulations, this framework, if you want to call it that, is fairly similar to the principles behind HIPAA. It doesn't require that you have absolute security. It requires that it's a reasonable basis, and you're allowed to take in factors such as cost and complexity and the nature of the information. So the GDPR really follows a risk-based approach that you see and that you're used to working with here in the U.S. When making decisions, therefore, about those kinds of controls that you need to safeguard personal data, the rules really require you to have a risk assessment performed. Again, this is something that you see in the U.S. You see this under HIPAA. You see this under the Massachusetts data security regs. And that's not any different here. And when you assess those measures, you have to consider all the kinds of risks that you might encounter. There might be risks from external attackers. There might be risks from inadvertent employee disclosures. Those all need to be considered and appropriate measures and controls put in place to try to address and minimize those vulnerabilities and those risks. Measures that you implement, you want to be sure that they're going to be able to protect personal data from unauthorized or unlawful processing, as well as from accidental loss, destruction, or damage. And this gets back to what Mary was talking about in terms of integrity, accessibility, confidentiality. So when you think about your assessment, you don't want to just focus on, can the bad guys access the data? You need to think about, okay, can the bad guys access the data? Can the employee inadvertently disclose the data? Can the data be corrupted? Your assessment should consider all of those things, and the controls should be addressing all of those things in order to ensure that you have appropriate security for your personal data. Examples of measures that are recommended by GDPR include pseudonymization, encryption. These are things that you see also in HIPAA, for example, where you have a rule under HIPAA that provides for you to de-identify data. And there's also an addressable standard for encryption of data. So again, trying to eliminate identifiability is a way to protect personal data. And also encryption is a way to secure it better from access in a more secure way than you might see for just a password or some other way when you're dealing with electronic information. Controllers and processors need to document the measures that they implement and the reason for rejecting other measures. This gets back to what Mary was talking about in terms of transparency and accountability. Documentation here, like in other standards and frameworks, is critical for being able to show that you've taken appropriate steps to protect that information and secure it. The focus, again, is on making sure the data is maintained confidentially, that the integrity of the data is maintained, that it's available if you need it, and that it will not be disclosed improperly. All of these issues, obviously, if there's a data breach, your security measures and the steps that you've taken will be looked at by regulators, not just the breach itself. And again, this is a similar pattern that we see in the US, where if there's a data breach, the Attorney General might investigate the breach, but they're also going to be asking about what were the mechanisms and safeguards and controls that you had in place prior to the breach to see that you had taken appropriate steps to protect it. privacy by design, as Mary started to talk about a little bit in her portion of the presentation, is something that you need to be thinking about, so that when you begin trying to develop a new process, a new product or a service, you want to think about how does privacy play into this. And that should also include how is this process, service, or product done in a way that keeps personal data secure. So you want to start and include that from the outset, not after the fact. And finally, in connection with data processor agreements, one thing to think about, in addition to pushing down basic security requirements, you want to think about things like indemnities, limitation of liability. Even though the data processor might, as Mary talked about, only be required to notify you, the data controller, you might want to, by contract, require the data processor to notify affected individuals if that's what makes sense under the circumstances. And you want to be sure that while you may have a data processor agreement in a situation that is an add-on to an existing master services agreement, be careful that the indemnification and limitation of liability clauses don't conflict with one another. We often see that happen when you're trying to address data security risks in that agreement, and you haven't really addressed it cleanly in the master services agreement. Can our U.S. employees access personal data of a data subject in the EU? So obviously, from Jason's definition of processing, accessing data would be a form of processing. And again, you're going to need to have a lawful purpose for that access, whether that be a legitimate interest, whether it be consent. But there must be adequate safeguards in place to facilitate a cross-border transfer of data from the Union to the U.S., for example, which the Union has determined the U.S. not to have adequate safeguards. Adequate safeguards basically means that the country or the company to which the data is transferred has data protection measures in place that are comparable to the GDPR. And if you've paid attention to some of the news over the last few years, at the end of the Obama administration and going forward, where the Union has challenged our government's enforcement of some of the arrangements that we've entered into concerning privacy, you'll know that the EU doesn't view the US as having adequate safeguards. So if your employees in the US are accessing data of your organization that may be in the EU, that's going to be considered a transfer of data, and you need to have some mechanism in place to ensure that we've maintained adequate safeguards for that data. That can be accomplished by the Privacy Shield. It can be accomplished by model contracts, binding corporate rules. Getting into each of those is beyond the scope of this presentation now, but it's important to recognize that as companies use IT cloud services, you use HRIS systems or other systems where you're accessing data that's stored in different parts of the world, attention needs to be paid to this to ensure that when folks in one country are accessing data in another country in the EU, there may be an issue about whether that transfer, that processing, needs to have certain additional safeguards in place that meet the GDPR requirements. So what happens if we do not comply? There are a lot of concerns about the significance and the enhanced penalties under the GDPR. My hope is many of you on the phone have already been far along in the process and are taking steps to comply, thinking about it. I have to also believe there's a lot of companies that are kind of trying to figure out their subject and taking other steps, but everybody's concerned about these penalties. What's interesting is recently there was an article in Reuters, I think in the last week, which said that about 2/3 of the countries in the EU really don't have the resources to be able to enforce the GDPR. Whether that is, some may take and say, well, then I got a get me out of jail free card. It's probably not a good plan. But to give you a sense for it, it's unclear how vigorous that enforcement will be. The hope is that there'll be a little bit of a grace period where the commissioners and different regulators will not start up on May 26th and start asking for inquiries and audits and compliance and enforcement, but it could happen. Investigatory powers require companies to provide information and submit to compulsory audit, so that's possible. There are corrective powers under the rules that provide for issuing warnings or reprimands. There are 2 levels of fees as indicated. Level 1 of fines is the greater of 10 million euros or 2% of worldwide annual turnover, and level 2 fines is 20 million or 4% of annual turnover. The difference in the fines is for level 2, they tend to be more serious. That's what they're going to be looking for when level 2 is assessed. That includes, for example, violating the principles of processing, violating the principles of obtaining consent. So again, it's important to think about that. Lawfulness of processing, access rights, failure to comply with an order of the regulators. So those kinds of violations might lead to a level 2 fine. You should bear in mind that natural legal persons may lodge administrative complaints before supervisory authorities. Individuals could authorize or appoint an organization or association or body to represent them. So you want to anticipate that there may be greater scrutiny from regulators, since it will be easier for individuals to exercise their rights. If you're a controller, bear in mind that you're liable for the damage that's caused by any processing that infringes on GDPR, including the acts of your processors. So, that takes you back into the indemnity provisions of those agreements that you want to pay attention to. So the enforcement landscape can be pretty dire given these amounts for some organizations. So it's important to think about compliance and have a plan that you're going to be able to show that you've met the requirements under GDPR, which again takes you back to what Mary was talking about in terms of transparency and accountability, being able to document the steps that you've taken. So with that, just to talk a little bit about kind of next steps from a takeaway standpoint. If you haven't gotten started, it's probably a good idea to do that. You want to be sure that you've mapped your data. You want to know where you're getting data, where it's coming from, the purposes that you're collecting it, who you're disclosing it to. And there's a variety of reasons for this. One is to be able to assert that you've collected it lawfully and have a legitimate basis to have it, but also when individuals begin to exercise their rights, such as, for example, the right of erasure, you'll need to know how to get data that you need to erase and where it is. You want to be able to make sure that you prepare your employees and they're trained to be able to comply with the requirements that are coming down. We talked about ensuring that you coordinate with the US and other laws. So if you have different frameworks and different rules, it'll take some time to carefully communicate those policies to the right persons. And you want to be sure, again, to document the steps that you take so that you can show that you complied. And also, documentation really will help organize your compliance efforts and make sure that you're following the rules on a consistent basis. So with that, our presentation is done. I want to turn it back over to the EVERFI team.
Thank you, Joe, Jason, Mary. Really appreciate your time and your insights. We've continued to excuse the noise in the background here in Midtown Manhattan. We have a lot of questions that have come in. A lot of them are very specific to individual businesses, whether you're based in the U.S. and don't have a presence in the EU, but there's data that could potentially put you in under GDPR compliance. So there's a lot of specific questions. I promise that these will be shared back to our friends at Jackson Lewis who will follow up. I want to take a minute now before we close out, just to close out on a couple things. And I'm going to ask everyone who wasn't able to submit a question but would like more information either from Jackson Lewis or for EVERFI to participate in this poll. It'll just take about 30 seconds, but it's letting us know how we can support you further. The poll is going to flash up on your screen now. Basically, obviously Jackson Lewis is helping a lot of organizations around the country and globally from an advisory services perspective. If you'd like to hear from Jackson Lewis, if you'd like to connect with them, if you'd like to learn more, indicate so. As I mentioned at the start of the webinar today, if you'd like to learn more, if you're a customer of EVERFI and you're interested in the new GDPR course that we have available in 20 languages, and making that available on our platform. If you're not an EVERFI customer but are curious about what that course looks like and how it can help train your employees, as our presenters just mentioned, educating the workforce is going to be an important piece from a next steps perspective. Please indicate there as well. And last but not least, just for those that joined late, we had about 350 folks in total join this webinar. We will be following up with the questions. There will be a recording that goes out early next week. We will be turning the presentation into a PDF and sharing that with everyone who attended and registered today. And again, my name is Preston Clark, President of the Compliance Division here at EVERFI. We support about 1,500 organizations and almost 2,000 colleges and universities meet their online compliance training initiatives. And if you've not worked with us in the past, we'd be happy to discuss how to work with us better in the future. For our friends at Jackson Lewis, Joe, Jason, and Mary, super valuable today. Thank you so much for your time. And with that, we will close down and stay tuned. We do webinars just about every month on various topics. And so if you've not attended a webinar before, you'll be on our list now, and we'll invite you to ones in the future. Thanks everyone so much for joining us today.